The next case to come before the court is 18AP0035 in re AA. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know. I'll be keeping track of the time. The arguments are being recorded. Please keep your voice up. Remain behind the podium. Be reminded, please, that you should not use the names of any minors in this case. Just use initials or child or anything but the names. We have read your briefs and are ready to proceed when you are.
Good morning. For the record, my name is Renee Jackwood. I am here today on behalf of my client, Angela Tucker. I would like to reserve 5 minutes, if you would be so kind as to give me the high sign when my time is up. We're really close to you. Angela Tucker lives in Shreve, Ohio, with her 8-year-old daughter, who's the subject of this case, along with her older daughter, who is 13, and her younger son, who is 1.5 now. Angela works full-time. She works an 8 to 4 job Monday through Friday, and she's raising 3 children as a single mother. The subject child, this is going to be hard for me not to use that name. The subject child's father left this home in Shreve in October of 2016, and a child support determination, administrative determination finding was done and set out in February of 2017. Instead of paying a child support, father filed for custody instead. The initial hearing was held at the end of February, and only father had counsel at that hearing. I, as counsel for mother, came in shortly thereafter. We continued to have some pre-trials. We continued to litigate the issue of child support. We were ordered both sides to file briefs on that issue, and those briefs were done and filed with the court in May of 2017. Despite that, no support has ever been paid by father. In my brief, quite frankly, I cited some things that in 25 years of practice I've never cited in a brief before. And even reading over it today in preparation for being before you today, I was taken back by some of the things that took place in this particular case. My client deserves to have an independent, fair, and impartial judiciary hear the case regarding the custody of her child. What doesn't translate to the written page of the transcript is the tenor, the volume, and the attitude of the hearing officer when she took over the questioning of not only my client, but some of my witnesses.
Do we have the audio tape in the record, in addition to the transcript?
That's a question I do not know the answer to.
It's clear from the trial court's ruling on the objections to the magistrate's decision that the trial court listened to it. It seems clear to me.
She stated that she had.
And that part of that tenor that you are talking about formed the basis of the trial court's ruling on the objections to the magistrate's decision. So we don't know as we sit here today whether it's part of the record or not, correct?
I do not know the answer to that question.
Okay. That's fine. I just, it was, when you said that, it's...
We don't generally get a list of what is sent to you. We just generally get a note that says it's been sent,
Mm-hmm.
and that starts our time limit. So,
And with the advent of some electronic filings, sometimes those lists don't always match. So, but thank you, counsel.
something I will check into.
I don't want
Thank you
to
for
take up too
your-
much of your time, but
No, I appreciate that. On pages 17 through 19 of my brief, I outlined 17 separate findings that the hearing officer made in her written decision as findings of fact, which I show in my transcript references supporting each one of those as being inaccurate as to what was actually testified to. One of the findings the magistrate made is that father is current in his support order. Well, that's not true. He never paid a penny. And he even testified that he hadn't paid a penny into mother's household for his daughter throughout the time that this case was pending. Then we turn to a stack of photographs. The photographs were faxed to my office just the day before the hearing, but at the hearing there were good, clear color photographs rather than the black you get from faxed photographs. And I think these photographs had an awful lot to do with the magistrate's decision, but the magistrate failed to weigh the evidence of these photographs to the fact of father testified that he took those photographs while he still lived there. He had lived in that house for 8 years. It had looked like that for most of the 8 years. When I asked him why he took photographs of the dishes in the sink rather than cleaning the dishes, he stated that he was trying to teach his daughter to be more responsible and to clean her own dishes. But yet the magistrate took those photographs and the evidence that was in them and placed all the blame on mother. She even said in her hearing that this was mother's responsibility to be taking care of the house better. The guardian ad litem was an actual person who went to the house. And throughout all the guardian ad litem reports, her recommendation never wavered that custody of this young child needed to remain with her mother. The guardian ad litem never recommended custody be changed to father. She recommended against any kind of shared parenting plan, but yet the magistrate ignored the guardian ad litem's recommendations and ordered a custody change. One of the findings that the court did make, which is true, is that mother smokes. That's true. The court didn't bother making the finding, that was also part of the testimony, that father smokes. He smokes a pack a day. He lives with his adult nephew who also smokes. They smoke regularly, daily. Both parties smoke, but yet it was used as a finding of fact against mother and ignored against father. One of the biggest things that the magistrates, I'm going to use the word biasness, but one of the things that seemed to really upset her is that mother had moved on with her life. After father moved out of the household, mother had continued to see a new boyfriend, and by February, March, that boyfriend had moved into the house. And at the time of the hearing in the summer of 2017, she was pregnant with his child. The magistrate decides that we want 6 months before mothers move on with their lives. But the evidence and the testimony is that father testified that he moved in with mother 8 years ago when she was still married to her previous husband. And they were again pregnant within just a couple of months of him moving in. But we find no fault with father for doing that. We are only finding fault with mother. And the magistrate very strongly cross-examined mother about that particular issue, telling her that she found it to be appalling, that it was not appropriate, and how dare she put her child into a situation where she was introducing her to someone else. All of those are referenced in my brief as to the transcript pages that goes on. One of the other things that mother was found fault with was the cross-examination of her about what was in the guardian ad litem reports. Now, in Wayne County Juvenile Court, we are not permitted to allow our clients to read a guardian ad litem report. We are allowed to read them, we are allowed to see them, but we are not allowed to have our clients read them. And in fact, in this guardian ad litem report, in red print, it even states, attorneys should proceed with caution when sharing details of this report with their clients. Adrian, the subject child, fears AA fears reprisal from Daniel, for potentially perceiving a weighted loyalty towards Angela and liking Richard, who is the new boyfriend. Angela does not feel safe around Daniel. That's what the guardian ad litem's putting in red, cautioning us even above and beyond what the magistrate, so what our local rules say that we're not allowed to show to clients. And as an attorney, I followed this. I followed this to the letter, but yet my client was cross-examined unmercifully for not knowing what was in this report. And did she do these things? Has she followed all the recommendations? We would just like for a decision for this child to be made on the basis of fact, evidence, and not conjecture and biasness, and on things that are equal on both sides of the coin here.
You're in your rebuttal time. It's up to you if you want to proceed.
And I appreciate that. Thank you very much.
Good morning. May it please the court, my name is Lori Fuchs, and I'm here on behalf of Dan Adams, the father in this case. You indicated you read our briefs, so I'm going to try to just address my points to what was argued, since I'm aware that you've read all of our points, just to highlight some of the things that I certainly disagree with relative to counsel on behalf of the appellant. She made an issue in the brief and argued today that my client, that there was an error in the court record, that the magistrate said that he was current in his support order. There was never a support order put on. There was originally an administrative order put on. We objected to it, and we filed briefs on it. During the case, there was never a support order put on. So there's never a support order for him to not have adhered to. However, as my brief recollected, he did provide support to the child, although it was never court ordered. He paid for daycare, he paid for medical expenses, he paid for trips that they did, he bought the kid a bike, he paid for all kinds of activities.
Is there any evidence of that in the record?
Yes, Your Honor, it's actually in the transcript. I can hopefully make a note here. It actually is in the transcript, Your Honor.
But there may be testimony that he did. Was there evidence that he did?
There was testimony that he did, but there was no actual receipts. But it wasn't ever controverted at any point by the mother in this case that what he testified to was not accurate. There was no opposition to that testimony. The counsel for the appellant argues that this judge showed some biasness and should be disqualified and should have been disqualified. As the court's well aware, the judge, as you indicated, the judge not only read the transcript, listened to the court record, and found that although there may have been some comments that she made on the record, that her decision was sound and based upon the facts in the record. And as we cite in our brief, the fact case law exists in Ray disqualification George, that specifically says even judicial remarks made from the bench which may be arguably critical or disapproving, it's assumed and presumed that the court's following the law and that their decision is based upon the facts in the record. And we believe the facts in the record were clear. There was an argument, and there was, to my knowledge, I don't believe there was ever any motion made during the trial, nor was there a motion made after the trial before the judge ruled on the objections to disqualify the magistrate. So I would argue that. I mean, I think that she waived that here even to address it on appeal because it was never addressed in the record period. And when she filed her objection, it was never addressed by a motion while the objection was pending before the judge made a ruling. It was only addressed in her objection, but she didn't file a separate motion, and she never raised an issue about it in the trial. In fact, there were times in the trial, which I point out in my brief, that she solicited commentary from the magistrate, wanting to know what her opinion was. She argued that the magistrate asked questions. As my brief pointed out, she asked questions on issues of clarification, which is what her job is supposed to do. There was very confusing evidence on the record as to the dental issue. She was just asking, I'm not sure what you're saying, I'm not sure what counsel's requesting, let's just get to the answer so I know what the answer is. That's what a judge is supposed to do. She asked her some questions with regards to counsel for appellate, asked a whole bunch of questions in the record, which I cite in my brief, saying, has he abused you? Did he hit you, etc., implying that my client had harmed this woman. And in fact, counsel mentioned that the guardian, in her report, said Angela was afraid of my client. The magistrate's like, has he ever hit you? No. Are you afraid of him? No. Has he ever done anything to cause you concern? No. That goes to issues of credibility, and that certainly is what the magistrate's job is to do in this particular case, and that's what she did. To say that that's bias, certainly I don't think the record is going to reflect that. Counsel, during today's argument, also argued photographs. That's the photographs. What counsel's ignoring in this case is there's no dispute that the pictures were taken by my client shortly before he left the residence after being asked to leave the residence in November of 2017. Those were the pictures then. But the guardian didn't go out to look at the mother's house until April 2018. My client hadn't lived there since November of 2017. The guardian testified multiple times and had in her report that she found the condition of the house that she observed in April of 2018 to be eerily similar to the pictures that were taken in November of 2017, which clearly demonstrates that nothing was done by this mother to rectify a situation during the 5 months that she lived there without my client living there. There was also testimony that she smelled dog feces and urine in the place. My client hadn't lived there for 5 months. And interestingly enough, as far as goes as credibility goes, even though the guardian recommended and said that she observed that and it was extremely potent, the mother denied that was even the case, which again brought some light as to the credibility of the mother in this case. Again, then, after the pictures come out and the mother has an opportunity to testify to it, we had an extension of time for the trial. I think that was in April. The last day of trial was in August, because we brought it up, the first day of trial was in July. But between April and August, the guardian went back out, and even then, though, she's like, it's been cleaned up a little bit, but there's still a problem with this house. And we've pointed to points in the record that reflect that. As a result of all of that, and what's ignored by counsel for the mother in this case is, the guardian made recommendations, and in her report she says, I think this woman's got some emotional issues, and I think she needs to be evaluated for hoarding behavior. And the mother acknowledged that she knew that. Now, whether you want to say she knew it before or after, but during the trial, in the 2 days, she knew it. As counsel, when recommendations are made, I mean, we're obligated to tell our client they're recommending you to do this. Just like he recommended that my guy get the daughter tested for ADHD. He did. Mother, in both cases, both trials said, I don't think I have a hoarding behavior problem. I'm not going to go get a mental assessment. I'm not doing it. And at the very end of the transcript, which we point out in our brief, the magistrate made a very important question to the guardian. She's like, do you think this hoarding behavior is having an effect on the child? She goes, yes. I mean, psychologically affects the child. She goes into whole details of why it can be harmful. The other harmful areas was mom clearly didn't want anybody in her house. The kid wasn't allowed to have friends in the house. And mom said, I don't plan on changing that. It's not, I don't feel comfortable. And there's points in the record where the guardian says, I think that's because her house is such a mess. She doesn't want anybody in there. But I think it is a part of her mental disability in this case. And she just ignored it. And I think when, at the very end of the transcript, when the magistrate says, if the mother doesn't get a mental assessment and the mother doesn't get evaluated for hoarding, and we told the mother that we think your kid has some social skill problems, you need to get counseled, and she says she's not going to do it, do you think you would recommend what you're doing? She says, I'd probably recommend custody to dad, which is what the guardian says in the report, at the very end of the transcript. So to say that she held her accountable for the pictures, that's really a skew, in my opinion, Your Honors, of the transcript, because I do acknowledge that was the condition of the house in November. And there's transcript testimony where my client said, I cleaned it, and the next week it would be the same. And at some point, I didn't do the dishes because I was trying to get her to do the dishes. But there is no explanation for the condition of the house 5 months later to be similar to the condition when my guy lived there, other than the fact that the mother just that she had hoarding behavior, and that hasn't changed, and she was very clear to say, I'm not going to change. I'm not going to get assessed. There was some testimony when she said the guardian never wavered. That's not true. At the very end of the transcript, she exactly says, I would probably recommend custody to father. She says mom was faulted for moving on with her life. That's also, I think, a very naive way of looking at the transcript. The magistrate found that the mother, within a month or less, had the new boyfriend sleeping at her home with her children there, with a child that loved her father, had great insight with her father, and then, during my cross-examination, she moves him in a couple months later. She's pregnant with his child. I asked her simple things like, when did he get divorced? I don't know. Well, what's his mother's name? I don't know. How much does he make? I don't know. Did you know that when did he leave his last girlfriend? I don't know. Did you know that when he left his last girlfriend, he stopped paying rent for her and her child and they got evicted because of that? And the mother's response was, those are just details I don't really need to be. Those are just nitty-gritty details. I don't need to know anything about it. That's what was the real evidence in the record as it relates to having this man involved. And to say that father wasn't treated the same, again, the record contains evidence that that's not the case. The magistrate did say to the father, when he was on the stand, well, you did the same thing. But the difference between that is, and the record reflects it, is that the father of the oldest child, 13, was a known drug addict, a known alcoholic, hadn't lived with them, was like sporadically in and out of that child's life, really didn't have much of a relationship with the child when my client got involved with the woman. By contrast, my client lived with his daughter and the mother from date of birth through the time when mom told him she wanted to leave because she wasn't in love with him anymore. And he had an extremely well-loving, bonded relationship with this minor child, and continued an extremely well-loving, bonded relationship with this minor child to this day. So there were some contrasts. And in addition to that, the natural mother's grandmother lived with my client and the mother during a large portion of the time that they were all together. So there were contrasting figures to that. But so I think that that's not an accurate perception of the record. I can't address the smoking issue. I will say both of them smoked. My memory is correct, and I don't want to say that it is. I think the problem is that mom smoked in the house with the child, and my client, there was no evidence that my client smoked with the child present, other than the fact he did smoke. And I could be honest, I could be wrong about that in the record, but my recollection is that's what the record reflects. The guardian, this magistrate had 96 findings of fact. 96 findings of fact. And my brief goes through each one of those and shows you the record facts in support of those findings of fact. Counsel likes to argue that she argued 17 of them weren't correct. That's counsel's interpretation. For example, counsel, I think, says on finding there was not enough time for both to play a sport, and she claims that was inaccurate. But the point of the guardian's recommendation was, and the guardian recommended, mom didn't have the kids in any extracurricular activities because she was too busy. So that's a finding that could be interpreted by the evidence. The father, there was some evidence that the father, that the photos over a period of time were not true. Well, the photos were true, and there was evidence in the record that I've already indicated that were supported by that. That she made findings, 4 findings, that her and this new boyfriend that she moved in the house had been friends for over 10 years and had known. But again, the evidence contained evidence that she didn't even know major facts that you should know about somebody before you move them into your house, expose them to your child, and have another child with him, particularly when you're relying upon him financially for some of your expenses. You don't know that he just left his last girlfriend, failed to pay the rent, and had his girlfriend and her daughter evicted?
Counsel, before we reach the end of your allotted time, because I don't think I picked up on it in the briefs, what is this court's standard of review for a trial court's decision that there's been no motion to disqualify, but trial court's decision that the magistrate's decision was sound?
It's abuse of discretion, Your Honor, period. It's abuse of discretion, period. And to get to the point, there is no evidence in this case under an abuse of discretion standard, and even that this record was not filled with substantial evidence to demonstrate and support the magistrate's conclusion. And the judge, in the entry that she did to approve the magistrate's decision, she says, although she may have made some comments that arguably were, I forget what her word was, you know, because you remember it. It's clear her decision was supported by the evidence in the record. And the findings of fact that she lists, 96 of them, clearly support her rationale. And at the end of the case, the guardian even acknowledged that's what she would do, because in the event that the mother wasn't doing any of these things, and the mother didn't do anything.
That concludes your time.
Okay, thank you, Your Honor.
Thank you, Counsel. Counsel, you have 4 minutes and 46 seconds.
Thank you. There never was a child support order put on by the magistrate, the hearing officer in this. We had an administrative order that was objected to by father as part of his initial filings, and the magistrate, we, as counsel for mother, we asked for child support to be put on. That issue was briefed, and the magistrate did nothing, never responded, never put an order on. Even in her final entry, she did not address all the retroactive child support that should have been paid by that point, because we had asked for it. It had been ordered in February, and by next November, we still hadn't had any payment whatsoever. So I would ask for that particular thing. You know, the law says that the court must consider whether or not the person asking for custody has fulfilled their child support obligation to all their children. This man has not. He still has not. He still hasn't paid a penny. The things that he did do was he bought her a bicycle for his house. She wasn't allowed to bring it home. He took her on a vacation with him. That wasn't anything that helped to financially support this child in her household. There are a lot of things that children need other than bicycles and vacations on a daily basis. Father was not recommended to get the child tested for ADHD. He was court ordered to do that by the magistrate. So that was not part of what the guardian ad litem's recommendations were. This particular GAL is a very experienced one. She's been doing it for many, many years. She knows that she's a mandated reporter. This household was not something to the level that she felt she needed to report this. This was never reported to CSB. This was a messy house. And we brought in people that testified about why it was. This was two households. Mom and dad and the kids all moved back to Worcester from Zanesville, and they moved in with her mother, who was suffering from breast cancer, and they took care of her. They moved all of their stuff in on top of all of Mom's stuff, and Mom came in and testified. I have since moved out, but I didn't take any of my stuff with me. Everything I own is still there. And she even testified that during the pendency of the case, she went in and removed 25 bags of her own clothing and donated them. That translated by the magistrate into 25 bags of garbage. We are just asking and urging you to remand this back to the trial court with orders that are consistent with the facts, and for custody of this little girl to remain with her mother so that she can continue living with her sister and her brother and going to school with her friends in the community that she has spent most of her life. Thank you.
Thank you. All right, thank you both for your presentations today. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on our website and that of the Supreme Court. We will